to wait 3 years before you can apply for your CHP.
Okay, any questions from the committee?
Have someone here testify. I'm sure if you will testify.
Well, person, no questions?
I have a question for council.
Okay.
It's a 3-year look back.
It is.
So why do we need the adjudicated delinquent?
So the adjudicated delinquent, Mr. Chairman, is in the situation where you commit the offense under, you're 17, you commit the offense, you're not adjudicated delinquent until you've been past your 18th birthday. You would still have, I mean, the adjudicated delinquent will fit a very small number of people. The bigger number of people that will be affected by this bill will be the people who are under 21 who get the 266.1 DUI and then need to wait their 3 years.
Not familiar. Yes, ma'am. Thank you.
Could I see the
Okay.
ordinance?
Any questions or any comment from the audience, the favor audience?
Make my limit on those codes.
You give your comments now.
Yes, sir, thank you. I didn't hear all of what Delta Bogey said, but we're basically dealing with a matter of,
Well, please state your name.
I'm sorry, my name's, I thought maybe you introduced me. My name's Bob Dees, I'm the sheriff of Williamsburg, James City County. Starting my 18th year. Before that, I had 30 years in the Virginia State Police. Our office processes concealed handgun permit applications. We did about 1,300 last year. Last summer, one came to my attention. A young man applied, had a violation 18.2 and conviction 266.1, underage drinking. And not long after, a few weeks later, applied for a concealed handgun permit, and there was no way to deny that. Where under 266, you would have to wait 3 years from the date of conviction to be eligible for a concealed handgun permit. To me, that just didn't seem to make sense, and that's why I spoke to Dr. Bogey and she brought it forward.
Thank you very much.
Yes, sir.
Anyone else would like to speak in favor of?
In favour, sir? Yes. Andrew Gollard, Virginia Centre for Public Safety. We support this bill. Thank you.
Anyone in opposition? Okay. Do I have a motion?
Mr. Chair. Can I just speak to it before we make a motion?
Yes.
I just want to be clear about what we would be doing. The offense of drunk driving is inherently dangerous, right? You're at such a level of intoxication that your ability to operate the motor vehicle is impaired. That is not the situation with the underage version of that. What is the 0.02 or greater? Mm-hmm. So there is no requirement under 266.1 that you are necessarily incapable of operating a motor vehicle because your motor skills are impaired. The public policy there is simply to deter people who are not otherwise eligible to drink legally from then also operating a motor vehicle. And I suppose I understand the nexus between the first thing and then being able to obtain your permit to some degree. I'm not sure I understand it as clearly in this context because of the lack of any inherent, other than you committed a status offense, really. And that status offense was then coupled with the act of driving. That's the kind of behavior we're trying to deter with that law, which I fully support. But I'm having a little trouble reconciling that with then depriving them of their ability to get a permit. And have you all contemplated, maybe the sheriff can tell me why he thinks one is like the other and why that then translates into depriving someone of their ability to carry lawfully with a permit?
Well, under 266.1, you can go up to 0.07, go close to that
Sure,
threshold.
I understand.
And in the specific case that I'm familiar with is 0.05. That I went through tonsillizer school, breathalyzer school, and you get up in that range, and to me, I can see where it affects. And these people have fewer years driving, less driving experience, less drinking experience, I would hope.
All of that is, Mr.
So,
Chairman.
to me, it just, it's this case, the young man beat the system, so to speak, even though it didn't preclude him getting
Thank
one.
you, Billy. Good.
No, I'll help send it to the full committee for discussion. I would intend to have this discussion again at full committee though, so.
All right, do I have a motion?
Move to report.
Second?
The motion been made and second to report, House Bill 1879, all in favor say aye.
Aye.
Opposed, no. The motion carries, the bill is reported. Next bill for delegate approval is 2369.
69 actually will make it easier for a law-abiding citizen to change his address on a CHP. And what it does is replaces requirement that a concealed carry permit holder present proof of a new address with the requirement that the permit holder present written notice of the change of address on a form provided by the Department of State Police for a court to issue this replacement card.
Okay.
This was brought to me by the CPL.
Any questions from the committee?
Mr. Chairman,
Yes, Delegate Bear.
State Police gonna make any comment on this?
Mr. Chairman, we have no position.
Any other questions from the committee? If not, those who wish to speak in favor or against? In favor?
Thank you, Mr. Chairman. Dennis O'Connor, Board of Directors, Virginia Citizens Defense League. We support this bill.
Okay. Anyone against? Okay. Any final comments from the committee? If not, we'll have a motion.
Motion report.
And a second.
Second.
Okay, the motion been made and second to report House Bill 2369. All in favor say aye.
Aye.
Opposed, no. The motion carries.
Thank you very
Um,
much.
Now we have, Delegate Miller has two bills, and we want to hear both these bills at the same time. They're related. If one, if there's no opposition, the committee will hear and vote. And then Delegate Bolton will be next.
Thank you, Mr. Chairman. Yes, sir. House Bills 2424 and 2468 are similar bills. 2424 is legislation that will allow retired and or resign, and of course under good cause, not retired, but terminated from a Commonwealth Attorney's Office. Allows Commonwealth attorneys to be able to carry their firearms. I think the purpose of this is very obvious. As I know Delegate Gilbert knows well aware, but I'm sure the rest of the members of this committee are very well aware that many Commonwealth attorneys will resign from their job after a major case. Maybe it might be a major violent gang type case or a major homicide case where the homicide suspect has friends or relatives that are very bitter with what happens with these cases. Or it may just be a very effective Commonwealth attorney who has put a lot of bad people away over a long period of time. There are several exceptions in the bill. For instance, the Commonwealth attorney that is, had either be resigned or retired assistant Commonwealth attorney has to have approval from the Commonwealth attorney. They have to, again, they can't have been fired or terminated for bad cause and the like. It's a fairly straightforward bill. I know you've heard similar bills, but again, I believe our Commonwealth attorneys do a pretty decent job protecting the citizens of the Commonwealth, and they do put themselves and their families in danger when they take this job on. I've had cases where suspects were more hateful to the Commonwealth's attorney than they were the law enforcement officer that arrested them. I have seen that.
Okay, any questions from the committee on 2424? Anyone here to testify?
I do not. I have Mr. Ebert, who is the Commonwealth's attorney for Prince William County, was very supportive of this bill, and he asked me that I will bring that forward and let the committee know that.
Anyone to speak in favor? Anyone in opposition? Do I have a motion?
Motion report.
No, Mr. Chairman, I think on behalf of the administration, this one and the workers' compensation judges would oppose, as I understood Mr. Miller, I think he laid out a good case, but for them to go and get a concealed carry permit, I think this just exempts them from having to get their own permit. That happens automatically, and so we'd oppose any expansion based for those two populations.
Okay. Well, right now, we're actually voting on the first.
take
Which one?
Do we take public comment yet?
Yes, there was no public comment.
2468, someone asked me which one.
Okay, this is 24.
Oh, I'm sorry.
Okay, do I have a, wait, should we make a comment? on
I'm
24?
confused and I apologize.
Me too.
I don't have a comment on 2424, I do on 2468.
Okay, well, you haven't explained that one.
Not yet.
Okay,
So
thank
we're just
you.
gonna go ahead,
Okay,
I
thank
said
you.
both of them, but I
Yeah,
think it's better
okay,
to
I
work
just
this
want,
way.
thank you.
Because it'll be almost at the same time.
Yeah.
Okay, we have a motion.
Motion.
A second.
I'm just making sure, Mr. Chairman, I'm just making sure I know what this does.
Okay.
You don't need a permit.
I believe that's correct.
Okay, all right. I will second the motion.
Okay, motion made and seconded, report House Bill 2424. All in favor say aye.
Aye.
Opposed, no.
No.
Okay, motion carries. Okay, the next bill is 2466.
No. Same thing. Right. Same
No, I
thing.
think you call it 2468.
It's very similar, Mr. Chairman. This could only apply to a,
No.
now, this is kind of some legislation that was brought forward to me. There's only approximately 23 Virginians that this could apply to. However, there's 3 of them that I know of that would very much like to be able to carry concealed into the workers' comp courtrooms, as they call them. I believe staff has a few kind of explanations to make here, or perhaps not. Basically, what's going on is these workers' compensation commission folks make some very, very serious decisions on people's lives and have, in some cases, been threatened. Some of their decisions can take away a person's livelihood and or fortune because that person was doing something wrong. And they've been threatened. They've had very angry people. They are often working in where they go to do their hearings, or often there's no security. That is the case. Sometimes they work late. There's no security guards. They did have to bring paid armed security to their Harrisonburg office because of some very upset Virginians that were very disappointed with the decisions they've made in hearings. And I believe these folks put themselves at risk just as judges do. And therefore we're looking to give them the same benefits that we gave to judges last year.
Secretary Moran, would you like to make a statement? I think it was actually on 2424 before. I think your comment was on this one. I was then confused the issue some at the beginning, but you'd like to make it.
Yeah, I just thought for the economy, I would just state our objection to expanding the kids. As I understand it, they could go get a permit now if they feel as though there's a justification that they're threatened. So we would just oppose a blanket exemption for them.
What this would do, Mr. Chairman and Mr. Secretary, is also allow them to carry in the courthouse, where others may not.
We're strenuously opposed. This would be exempting,
This is where they do a lot of their hearings, just like judges, as we define.
Mr. Chairman, I suggest there are bailiffs in this law enforcement who are permitted to carry and are well-trained with these firearms, and that's why, we have court cases every day where lives are at stake, very emotional cases. We do
Mr.
not
Chairman.
permit people in the courthouse with guns for that very reason. I think it should be, the safety and protection of those in the courthouse should remain with those bailiffs that are trained in sheriff's office.
Mr. Delegate Gilbert.
Mr. Chairman, I am a little confused, admittedly, because last year the administration signed the bill that lets judges carry without a permit in the courthouse and everywhere else. And the rationale I just heard would have applied to that, I would have thought.
And Mr. Chairman, if I may, just let the Secretary know, some of these commissioners are not working where there's armed bailiffs. And their hearings are in rooms where they do not have security. That does happen in several other locations around the Commonwealth as well.
Anyone else wishing to speak in opposition? Or you got any further
No,
comments?
we're opposed.
Yes, ma'am.
Good afternoon, my name is Lori Haas, I'm with the Educational Fund to Stop Gun Violence. We took no position on the previous bill because it had a training element to it. It required these retired Commonwealth's attorneys and assistant Commonwealth's courthouse attorneys, if I read the bill correctly, to have some training component to their premise of being able to conceal carry. And I understand the delegates' contention with regard to persons maybe wanting to get concealed carry permits. I'm not sure I understand why these workmen's compensation employees can't get a permit, but there is no training element required. And whereas in sensitive places and other places where you want to be careful and safe with that firearm, especially retention, we know that our law enforcement undergo quite a bit of training with regard to judgment, muscle memory, retention, all sorts of responsives to being threatened with a firearm. This bill doesn't have any kind of training involved. So for that reason, we oppose the bill.
Anyone else in opposition? Anyone in favor?
Mr. Chairman, I'm Wes Marshall, I'm the chairman of the Workers' Compensation Commission. Just want to let you know we do not have any formal position on the bill. Happy to answer any questions you may have.
Anyone else speak in favor? Any committee member have any questions?
I didn't want to make a statement, just
Delegate Gilbert.
in case I'm confusing anybody. I think Delegate Miller understands my position on this. I am a little confused that the VCDL folks have not said anything about either of these things. Well, good for you, but I'm not on board. So I think everybody who's a law-abiding citizen should be able to carry a weapon as they see fit without a permit, and I don't want to carve out special things for special people who think they're special, and I thought that was your all's position too, but I'll take up the mantle this year on your behalf. I'm happy to help the bill go along, because we are short a couple of people, but I'm going to vote no for that reason.
Any motion? No motion to do. Next, promised Delegate Holden, since he's been here, he can. And next, then we'll have Delegate Murphy, and then Delegate Simon.
Thank you, Mr. Chairman, members of the committee. I have a substitute for this bill.
Anybody need a substitute?
Motion to,
It's judges and commissioners.
Motion made and seconded to accept the substitute. All in favor say aye. Opposed, no. The substitute is
Carry
before.
that bill. Okay.
Delegate Holden.
This substitute, what it does on House Bill 2372, it cleans up the bill and takes out some of the redundant languages. They're on line 15, 16, and 17.
Okay. Questions from the committee? Delegate Gilbert.
What does this do?
On line
I
15.
see that, but what does it do?
Well, it takes out the redundant language there, and it also cleans it up where it says, takes out, puts a shall in and takes out establish. It says shall make such determination on line 15.
Okay, let me do something more fundamental. What is this whole area of law about, and why? Who needs this change, and why?
Well, it affects the state police and defining what they need to do with their firearm transactions for a background check for persons other than dealers on a voluntary background check. And so it clarifies it and establishes exactly what has to be done.
And this is a state police bill, or whose bill is? Who brought you this bill? What medium I want to say that? Whose idea was this ultimately? Unless you were sitting around thinking about this
No,
on your special election night.
Let me just ask the state police if they have a.
Mr. Chairman, Keenan Book, with the state police, we have no position on this.
Mr. Chairman.
Yes, Delegate Bell.
I think Secretary Moran, are you still back there?
I am, sir.
Yeah. I mean, since this
Please
was
come forward.
wanted to see if the administration had a position. This is part of pretty complicated deal last year. I mean, my read is it doesn't seem to change anything, but just wordsmithing.
Yep.
You know, ask the secretary if you had any opinion on that, given that deal's pretty recent.
Delegate, I very much appreciate you soliciting my input, and because I was just handed the substitute, and I don't know what the purpose was or why this is coming forward. I didn't know there was a problem with the existing language, so I'm always averse to changing language that doesn't appear to have a problem. But if there is one, then we'd be happy to work with the delegate. I don't know if this causes mischief or not, frankly. It appears to say the same thing, but in a different way. But
Yeah, I think so.
I think
question is, what problem are we solving
Well,
with
again,
this, because it doesn't seem to change anything.
it's taking out some redundant language there on line 15. It's repeated there on line 17 at the end. So it's just, again, it's just cleaning up, making it more specific and taking out some redundant language.
Mr. Chair,
Delegate Gilbert.
I believe this is something the committee chairman may have given the delegates because he had thought it was important in the off-season to clean that up. I do believe it says the same thing in a different way, and I don't, Delegate Lingenfelter would know the precise who told him it needed to be reworded, but that appears to be how we got where we are.
Okay, any comments from the audience? Yes, sir.
Simply a comment, sir, and that is that the bill is very, very different to the one that was initially introduced. This is not just a change of, obviously Latin mutatis mutandis is now acceptable. And something else got picked up in its place. That's fine as long as it doesn't do anything other than linguistically.
I'm ready for a motion, with no further questions.
I move to report.
Okay?
Second.
All right, motion was made and seconded to report this new bill, and, all in favor say aye.
Aye.
Opposed, no, the motion
No.
carries.
Just so it's debated at the next level.
That's fine.
We can't let you off too.
Yeah, that's fine. That's fine.
Thank you, Delegate.
Mr. Chairman, thank you.
Okay, next bill is, Delegate Murphy, 2044.
Deck chair. Scott, they proud of you.
Wrong binder. Yeah, I think it has to be in order to. Yes. Yes. Mr. Chairman, this bill, we're trying to keep it in line with what passed over in the Senate, so that we don't complicate life.
You probably seen Diet Coke all in one forever.
Okay. So,
Let's not push into the delegate.
so, I'm not really sure how to do that. Do I say I offer this as an amendment in the nature of a substitute?
If you've got a substitute.
Yeah, please.
Okay, all right.
If you get
Do I have
one.
a motion to accept the substitute? Motion. Second. All in favor say aye.
Aye.
All opposed say no, the substitute is before you.
To a substitute?
Yes, ma'am.
Yay.
Delegate Murphy,
Right.
substitute.
Yes. Well, last year we had, an agreement to take, guns out of the hands of people under, permanent or final protective orders, due to domestic abuse. What this is trying to do is, to prohibit persons subject to that same final protective order from possessing firearms the same way that we did it last year, only expand it to include people who were not related by either marriage or had a family relationship, or wasn't a roommate or wasn't dating. Well, actually might be dating, because that's not a family relationship. If you look at the Yardley Love case, this would have been a great example of someone who could have used this kind of protection, because it was a boyfriend who was abusing her. But this bill, it's a simple thing. It just would prohibit persons subject to a final protective order that has been decided by a judge, who they've decided that they are indeed a threat. It prevents them from possessing firearms while under this protective order.
Let me just say, this does expand the agreement that we had last year where it would be, a protective order dealing with domestic abuse. And I'm not sure what would not be included in this as far as protective orders. Maybe Gilbert is.
Maybe test our counsel and see if she knows.
Mr. Chairman, this would not apply to emergency or preliminary protective orders that have a more limited duration of 24 hours or 15 days.
Okay. But it does expand, value.
Mr. Chair, am I correct that it,
Delegate Gilbert.
this 19.152.10 is, what type of protective order is that?
That would be a permanent protective order.
Right, but so is 16.1.279.1. I'm
Yeah.
saying what type of, like, 16.1.279.1 is the family, this is the non-family?
This is the non-family.
Okay, all right, so this expands it to boyfriends, girlfriends, neighbors, coworkers, dude
Who
down
have
the
been-
street that, I understand.
been judged
Yeah,
to be a
absolutely.
threat. This is not just somebody who annoys you because they chew gum too loud.
Well, this
is
is
a threat.
protective order, we
Yes.
understand
Yeah,
that.
the judge has determined in court that this person is in reasonable fear of this other person, but I'll get back to that in a minute.
Okay.
Okay. Delegate Moran, I think you're chomping at the bit.
No, whenever you're ready to take, public comment, happy to.
Well, I just have one other thing. The bill closes the gap between the Virginia law and the federal law, which prohibits persons subject to final protective orders from possessing firearms. But Virginia law enforcement officers are not able to make arrests based on federal possession prohibitions. So this indeed would cure that.
Before I get comments from the committee, I'll ask Delegate Moran, does he have a statement to make or a comment on the bill he'd like to make at this time?
Mr. Chairman, thank you, members of the committee. With the substitute, I think you have before you just a straight up policy decision. Last year, through a lot of negotiation, worked with the likes of Delegate Gilbert and others, we were able to get a historic
Just barely.
bill done, barely. That's for sure. I can attest to that, but, and at that time, we discussed including other protective orders. Straight up, I'll tell you, and it was rejected. But at that time, while we negotiated this, we discussed, well, next year we're gonna put in, if this is good for family abuse cases, now it is particularly good for family abuse, because those cases, we have data, 66 lives were lost in 2014 by firearms in that very volatile family situation. So that was indeed our priority at the time. But this legislature has deemed non-family abuse protective orders to be equally dangerous as family abuse orders. 19.2-152.10 is exactly the same as 16.2, which addresses family abuse. So this legislature has deemed them to be equal. And so that is why we come before you this year, asking you to expand it. We've had tremendous success. There are prosecutions around this Commonwealth. I've spoken to prosecutors around this Commonwealth. This is a real important tool for them, particularly now it is the felony punishment that they are using it. And so this is a good piece of legislation, and it is just now essentially a policy decision for this legislature to adopt. And just for purposes of some additional data, it's about 5,800 of the family abuse orders that the law now addresses. This would include about 2,800 that are in general, about 2,500 in general district court, about 300 in JDR court. And so it would expand to about 2,800 additional protective orders per year. Obviously, it fluctuates by year to year, but those are 2015 figures. So we would ask, and again, this is a full protective order. This is the one after the judicial determination, not emergency or preliminary, but a permanent.
Thank you, Mr.
Thank you very much, Mr. Chairman, for hearing me out.
Anyone else speak in favor? Yes,
Mr.
sir.
Chairman, Andrew Ballard, Virginia Centre for Public Safety, we support the bill for the reasons stated.
Good afternoon,
Yes,
Sushila
ma'am.
Varkin from Virginia Poverty Law Center. As Secretary Moran mentioned, in 2010, I believe, we made the non-family abuse protective order the same as the family abuse protective order. It's an act of violence, force, or threat without the family or household member relationship. And so I would say, even though this is an expansion of the prohibition on possession of firearms, there are folks who are victims of sexual assault, victims of dating violence, who go through general district court to get this type of an order. So I support this bill.
Thank you.
Thank you.
Anyone else in favor?
Yes, sir. My name is Lori Haas. I'm with the Educational Fund to Support Gun Violence. We wholeheartedly support the bill. We believe that if the situation warrants a permanent protective order, in either case, in the family abuse or in this case that the delegate is trying to add, that the circumstances are equally and likely as serious to get that second type of permanent protective order. And so the threat is just as real. It doesn't and shouldn't matter to the Commonwealth if the people do or don't live in the house with the petitioner. So for a lot of reasons, we support the bill. Thank you.
Any speaking against the bill? Yes, sir.
Thank you, Mr. Chairman. Dennis O'Connor, Board of Directors, Virginia Citizens Defense League. VCDL strongly opposes this bill. We don't believe the state should be expanding its stripping people of their right to defense where there is no cause or justification to incarcerate or to convict someone under current law. Thank you.
Yes.
Aaron Luker, National Rifle Association. We oppose this bill. First of all, these orders don't require a special relationship between the petitioners and the respondent. Second thing is the judges already have the authority to restrict firearm possession on a case-by-case basis under existing law. They can order any relief where it's necessary to prevent acts of violence, force, threat, or criminal offenses that may result in injury to a person or property. And also, the NRA doesn't support the premise or idea that those who pose a real danger to others should be allowed to possess firearms. However, current law already recognizes the judges properly have within their discretion the ability to intercede and impose such restrictions where appropriate.
Okay, we've had comment on the bill. Anyone who is in favor would like to raise their hand or stand rather than speak, that would be fine. And the same thing in opposition. Anyone that hasn't spoken, feel free to raise your hand. Okay, thank you very much. Any questions from the committee?
I have a question for anybody who can answer.
Doug, question anybody can
Does anybody know how many of those permanent protective orders that are issued for this type of new offense, how many of those folks, and I know they've gone through the process in court, how many of them availed themselves of their right to counsel in those instances where they actually had a lawyer? This is what I was talking to you about earlier, that a lot of these things just are two people showing up and rolling the dice. And I'm just wondering how many of them actually have counsel.
That's a good question, but I want to ask you a question.
Well, could you answer mine first?
I said I don't.
Oh, okay, all right,
know.
okay. Yes, ma'am.
Okay, I'll give you the last word.
It's a question.
Well, you can include that in your final.
Oh, okay.
Statement.
Well, I'm not an attorney, and so I cannot tell you how many times you go to court before you get to the place where you're getting a final protective order. I don't really know what that process is, so it's hard for me to answer, but I would assume that people would have representation when it gets down to that far into it. Could be wrong, but it seems that it makes sense to me that if you are a person and you have someone who is violent and hurting you or threatening you, and they have hurt you previously, I don't really understand why it wouldn't be appropriate to take that extra step. And when you're a judge judging that this person is in fact a threat to you, he could not also say, and you have to give up your gun because now you're under a final protective order.
Well,
These, by the way, I don't believe are forever. I think that they have time limits. I believe 2 years, at least, it could be more sooner, but I believe that they're for 2 years in the worst cases, and then they can be extended.
Mr. Chair.
Go.
So when we expanded protective orders to this sort of no special familial relationship category, this has probably been one of my biggest regrets that we expanded it this broadly, because I see all the time how people use this mechanism in neighbor disputes, other things where they're just trying to get back at somebody, vindictiveness, trying to get a leg up in some sort of civil matter, custody matter, whatever it may be, where people don't have that special relationship that's covered by the 16.1 language, but they're trying to get back at the other person, or they're trying, all kinds of stuff. So to my mind, I remember complaining at the time. You may have been there when I was complaining about it, I don't know, but.
2011, no.
Well, okay, but it was gonna clog up the courts. And I don't know that it's clogged up the courts, but it has definitely, created yet another reason to start what we call the race to the magistrate. Like, who's gonna get there first and go tell them this tale of woe about how much they're scared of this person, and then, oh, I got my protective order and now we're going to court. And I see it play out all the time. So I know you have this vision of someone in dire need of all the protection they can get, and certainly that exists. And certainly there are people that are legitimately in fear of people. Again, I've never agreed that the way you're approaching this is actually a way to actually make someone safe, because someone bent on killing another person is never going to be deterred by yet another little crime that they might get convicted of while they're getting convicted of capital murder. So I've never agreed with the logic, but I also don't agree that this particular code section is anything other than a big mess that plays out every day in the courts of the Commonwealth as just a way to be vindictive against people. In large part, again, not saying there aren't legitimate people who avail themselves of this, who are legitimately scared, who need protection, who need the protection of the state, who need their guns to protect themselves. But there are so many reasons why it's a terrible idea to take people's rights away based on this very overly broad, overly applied statute. And so that's what I was trying to articulate to you earlier when we spoke privately, is that was my concern about how this actually plays out, that it's not always the person who's legitimately in fear and has a real threat. And so that's my concern, Mr. Chairman. So.
Any other questions from the committee? This time we'll entertain a motion.
Motion report.
Hearing no second, the bill.
Oh, that's fine.
Fails to review. Thanks. Delegate Simon, House Bill 2466.
Thank you, Mr. Chairman, members of the committee.
Yes, sir.
So I am back in my never-ending quest to try and protect children from the dangers of gun violence. My dad called me the other day. He heard Blake Weaver on the radio and wanted to know why it is that I'm unconcerned with the safety of children. And I could explain to him that I'm really very concerned about the safety of children and guns. And this is one more bill I think it could help with that. This doesn't take away anybody's rights, doesn't restrict anybody's ability to carry whatever kind of firearm they want anywhere they want at any time. It's a little unusual for me. This just says that you've got to require that licensed firearm dealers carry in their inventory at least one personalized handgun for sale. So they don't have to sell it, nobody has to buy it if they don't want it, but we want to make this 21st century technology available to folks in the Commonwealth of Virginia. That's all. Between 1999 and 2014, nearly 7,000 children committed suicide with guns. Thousands of people were killed every year with misappropriated guns. I had a bill in here last week, which I thought would be useful to restrict handgun purchases to one handgun a month, because people buy guns and they get sold, and a lot of the crime guns are guns that are stolen or lost. So if we gave people at least the option, particularly people that have children in their homes, they don't want to have to balance that risk. They want to have a gun for self-protection in their home, but they're worried about the risk that that gun is found by a child. You hear stories frequently about folks that fall asleep after a long day at work, and a young child finds their gun in their purse. We had a police officer whose gun was found again on a coffee table. I was asleep on the couch by one of his children. You hear those kind of stories all the time. We just want to give folks the option to have a 21st century gun with technology that says you can't use it unless you're the person. Just like somebody can't get into my iPad, unless they put the thumbprint on and make it go. It's pretty reliable technology. It comes on every time I touch my thumb to it. It's pretty proven technology. These exist in other places. The technology exists. So why do we have to have this bill? What do we need a bill to do this for? The problem is that a lot of firearms dealers are sort of bullied into not carrying these kinds of firearms in their store, in their inventory, by folks that are afraid that this is a slippery slope, that once we have the availability of smart guns, that somebody's going to try and require it someday. So I'm trying to push back a little on that and say, look, if you're going to sell handguns in Virginia, at least give your customers the option, if they want it, to buy a personalized handgun.
Anyone in the audience wish to speak in favor?
Mr. Chairman, I had a question.
Okay, just let me get this man first.
Okay.
Go ahead.
Mr. Chairman, Andrew Gallard, Virginia Centre for Public Safety. We'd like to see this innovative solution to unauthorised handgun use field tested in the real world. I know that Delegate Gilbert's very concerned about domestic violence victims being able to arm themselves. This might be the ideal one to have as a gun that would only fire in the hands of the person who was the victim. And if they were overpowered and lost possession of the gun, it wouldn't be used against them. I also would like to see an end to the idea at some point in the future, not with this bill but another bill, that police officers would be able to not to be able to be shot with their own weapon. Thank you.
Bill, okay, I'll take public comment first and come back.
That's fine.
Hi, my name is Lori House. I'm with the Educational Fund to Stop Gun Violence, and we support the bill for the reasons stated. Thank you.
Anyone else in favor? In opposition?
Thank you, Mr. Chairman. Dennis O'Connor, Board of Directors, Virginia Citizens Defense League. VCDL strongly opposes this bill. The delegates suggest this is to provide an option, but if there is reliable technology out there, the option's already available. What this bill would do is put a huge financial burden on dealers for something that isn't out there in a very reliable way right now anyway. The fingerprint technology, it fails with sweat, with blood, with mud, with any kind of things that happen in real world combat or tension situations. You note that there's exemptions for law enforcement agencies. There's no demand from that from them because it's not a reliable technology now. Maybe it will be someday, but in the meantime, if there is something out there and manufacturers are coming out with that, if the demand is there, dealers will carry it and they'll always have the option for it, and it shouldn't be mandated as a huge financial burden on dealers. Thank you.
Okay. I had one other person I think who wanted to speak.
Oh, I was just raising my hand in opposition.
Okay.
NRA, Aaron Looper, we oppose it.
Okay. All right, committee questions. Bill.
My question's pretty easy one, Mr. Chairman. Inventory, would that include, let's say, I know some small dealers will basically order, they'll have catalogs and they order from. Would that include what they're available to sell, or do they actually have to possess it in a physical inventory?
I prefer council drafting it on that. I think that sounds to me like we put in that category, but.
Mr. Chairman, my understanding of the term inventory is used here would mean that it would have to be available in store for sale.
Mr. Chairman, I would just offer to the patron perhaps changing that term so that it wouldn't be a financial burden. They would just have to have the ability to offer that I know when I purchased a firearm, it wasn't physically in inventory, it was in catalog. We were to order it, the dealer then had it days later, so it wouldn't be a financial burden, but it would be available for purchase from that particular dealer.
So we could strike the words from his inventory, just make available for sale, at least one personalized handgun, and then that might address the concern about the financial burden that we just heard from the VCDL, so.
I'd ask council, would that take care of the request of Doug Bill?
Mr. Chairman, I believe that striking from his inventory, or adding after making available for sale from his inventory, some language along the lines of, or the ability to acquire for his inventory. But I think that striking from his inventory would accomplish.
We'll consider that amendment in concept if you have to work on it. And first of all, I have a motion to adopt the amendment.
Mr. Chairman, I have a few more questions before I would do that. How expensive are these guns?
I don't know. That's a good question. I don't have a catalog. I don't know that they cost much. I mean, there's a range, I assume, like with all firearms and price point, but I don't know what the cheapest and what the most expensive are.
Mr. Chairman, two more questions, if I may. One of them, do these guns work with multiple fingerprints, or they just work with one fingerprint?
There is technology so that you could. There are a number of different biometrics. So it's not necessarily just a fingerprint. Some of these are token based, where you can wear something on your wrist, so anybody who's wearing it on their wrist can fire the gun. And some of them are programmable, so you can program multiple fingerprints. If you wanted to have the adults in the house, just like I can have multiple fingerprints for my iPad.
That's it.
We're considering the amendment right now. So
oh, okay.
I gave you the latitude of asking your question, that was really relevant to the amendment. Do I have a motion on the amendment?
Motion to adopt the amendments.
I have a second.
Second.
Okay. Motion's been made and seconded to adopt the amendment. All in favor say aye.
Aye.
Opposed?
Yeah, I have to.
Motion
Absolutely.
failed.
Mr. Chairman.
Delegate,
All right.
Gilbert.
So, do you even have a basic understanding of how the gun shop, the business model of a gun shop works? Like that there are dealers who deal with manufacturers and they have agreements with those manufacturers to carry their products, and maybe they don't have agreements with people who make these kinds of guns, which I don't even know who that is. You'd be telling somebody that they would have to have an agreement with a manufacturer of this specific type of firearm to be able to sell any other type of firearm, right?
That's right.
Okay. So who makes these things?
Let's see, I've got a list of folks that make them.
Do you have copies of their agreements that they require their dealers to carry their products?
I do not.
So you don't know how onerous they are or what they contemplate or anything of that nature?
Nope.
Okay, I'll let you tell me who makes them if you were looking for that.
I don't know that I actually have a whole long list of the manufacturers. Let's see. Armatix IP1 has a smart gun. There's RFID technology. So there are some overseas manufacturers. I think Smith & Wesson had a smart gun that they had manufactured at one point as well.
Okay, if there's no further questions?
I have one question, Mr. Chairman, maybe, and this is if anybody can answer. Do we tell automobile dealers that they have to carry cars that have automatic braking systems?
I think we do. I think we require airbags. I think we require automatic braking systems. I think we're now phasing in anti-tip technology and those sorts of safety features. We have lots of mandatory safety features in cars.
Okay, I have a motion.
Motion for it.
Hearing no second, motion fails.
Thank you all.
Thank you. Committee's adjourned. I want to thank the committee for this hard work. I think this will be our last meeting this committee of this high school.